So what I thought we would do as an introduction to delinquency, because all you had to do for today was read the statute. We don't do the cases until next week. Let's use the Richard Ortiz facts to first quickly identify how he would be the basis for a CRA, and then we'll get to delinquency and the more serious youthful offenders. So, somebody give me one of the facts contained in, the Richard Ortiz hypothetical case that I gave you guys that would subject him to juvenile court jurisdiction for a CRA. And remember, there are only 4 ways that you can, as a child, get into court on what was previously a CHINS, a CRA today. What were the 4 ways, just to sort of summarize? Anybody know?
Yeah, runaway.
Michael? A runaway?
Stubborn child at home.
Refusing to obey rules in the house.
Truancy and school offender.
Yeah. Again, refusing to obey in a willful, persistent manner the lawful and reasonable regulations of the school. So do you see any possibilities for any of those 4 in the Richard Ortiz hypothetical? Laura?
I thought the school offender.
Give me a fact, and I'll just put the fact up there, and then we'll put the school offender underneath.
Okay, his most recent situation was he assaulted and battered another student with a hockey stick.
Okay.
So
all right.
That's against the school's
policy
of school violence.
Okay, so we'll say the hockey stick. So there might be a few. Let me put up top. So violating school rules. And so the school rule, obviously, that would have been, in, say, the school handbook that all the kids get at the beginning of school. How is hitting a kid in gym class with hockey stick a violation of a school rule? What do you suppose the school rule would have said? Something like...
No violence.
No violence.
Yeah.
No physical contact.
Yeah, exactly. What else besides the hockey stick situation?
Well, while he was on suspension for the hockey stick incident, he was assigned paper, and he didn't write any paper at all.
But instead did what? He did what?
I thought that he wrote about the teachers and the administration.
Yeah, so we'll say the suspension in quotes essay, because he really didn't write an essay, he wrote a list, right? And at the end of the list he said something like, we should take up arms if we're, if we're harassed for any reason, that sort of thing. So that would have also been some violation of a school rule, right? And the school, for that reason, might be interested in a CRA. You don't have many facts about mom and the home situation, but there was one fact. You remember when she came and met with the school? Who did she meet with? The vice principal, or was it with the counselor? The principal? And she said to the principal, well, he's at home, he doesn't, whatever. There may or may not have been some issues regarding that. Obviously, if you look at the statute, you have to have missed something like 8 consecutive days at school to be truant. But maybe, depending on the facts, if you have a situation where he's consistently staying out, and again, he could be staying out because he's being bullied, but technically it may fall under CRA. So we'll put, question mark, truant, might have been an issue, who knows. And in that case, in all 3 of these, we're talking about the school as the petitioner, correct? Okay. Anybody else want to say anything about CRA? Any questions about it with regard to, a situation like Richard's? Because I want to move on to the delinquency and YO cases, again, using his facts as a backdrop.
My only comment would be on the school violence. There were a couple of situations that he had done, which would help the Commonwealth prove that it was persistent. It wasn't
that his behavior was persistent.
Yes.
As a sufficient evidence to have an application actually issue and for services for Richard and his family and so forth and so on. Okay. All right. So keeping those facts in mind, now let's talk about as a result of anything that you saw in that fact pattern, could he be subjected to a delinquency complaint? And really, are we missing something here? Wasn't there another incident that may or may not?
Oh, he threw the brick.
Yeah, let's put the brick through, and I'm going to actually erase the truancy situation, because we're going to see that I really wanted to talk about these three sort of facts being also possibly elements or reasons for either a delinquency and possibly a YO case. So, hockey stick.
I don't know which one of the section numbers that it's under, but
It's one of the
assault
265.
battery.
Yeah.
um,
So what, first of all, in the statute that you guys have, and you heard Michael Kelly talk about it last week, the legislature just in September raised the jurisdictional age for juveniles to 18. So where you guys have 7 to 17, if you printed it out or whatever, if you saved it on your computer, it's 7 to 18. Okay.
Inclusive, I'm sorry, inclusive?
Yes, so 18, you committed an act on, if it's after your 18th birthday, obviously you're going to district court, same thing as before. If it was after the person's 17th birthday, they would have been in district court or superior court rather than juvenile court. And then don't get confused, and I'm not going to get into the situations where you're apprehended after, so you could be subjected to juvenile court jurisdiction after age 18, but again, the cutoff is, have you allegedly done the crime on or before your 18th birthday? So just think of it that way, it's much easier.
That's what we saw.
What's that?
When we were there on Monday, we saw that. There was somebody that was like 27.
Oh, that's right, you wrote that in your essay. Yeah.
That committed a crime when he was like 12.
Yeah.
And
Yeah.
so he was under the juvenile.
Yeah, weird, huh?
I have a question.
That was a strange case.
Does that
Yes.
go for like a major thing like vehicular homicide and those kinds of things?
Hold that thought, because that might get into the YOs, and then even the jurisdiction of the Superior Court for the murder cases. So hold on to that thought for now. So, hockey stick. It's a delinquency complaint by reason of having violated certain laws of the Commonwealth. So it's somewhere in the 265 range, 13, I think, and up. Could be as little as assault, could be assault and battery, could be A and BPW, assault and battery, dangerous weapon, etc. But the main complaint is a delinquency complaint. So if you look at the definition, if you have your statute in front of you, again, substitute 18, a delinquent child is a child between 7 and 18 who violates any city ordinance or town bylaw, or in this case, commits any offense against a law of the Commonwealth. In terms of that language, violates any city ordinance or town bylaw. I think I gave you guys yes, I did. For next week's reading, the Commonwealth v. Weston case that you have is actually a case that came out of Lowell, where Lowell had a, quote, a juvenile curfew. So it did fall under this definition, violation of a city ordinance or town bylaw. So we'll talk about that case next week. That case came out of Lowell, where the juvenile challenged the constitutionality of Lowell's juvenile curfew ordinance. And actually it was an MSL alum who was, trial counsel who filed the initial motion, and it was, I can't believe I forgot his name, Henry? It was one of the first juvenile law interns that we had that actually wrote the motion to dismiss, and Judge Blitzman actually reported it, I was trying to think of the procedure, he reported it under Rule 34 to the appeals court, and the SJC ended up taking it. So that's the Weston case. So anyway, the definition of delinquency is you could violate just a town ordinance or a really, serious law of the Commonwealth. But it's from age 7 up until 18. So for your CRAs in the care and protection case, remember we kept coming back to like the purpose of, we kept saying care and protection proceedings, strengthen and encourage family life, best interest, and that was all in 119 section 1, which was the purpose clause of the statute. And actually the purpose clause of the delinquency statute is in section 53. And it's interesting because here you have now criminal cases, right? Juveniles charged. We're talking about Commonwealth versus Ortiz, right? For your delinquency case, for your YO case, whereas your CRA case would be something like, in re or CRA of. Okay? So these are criminal cases, yet the purpose, and it hasn't changed for years, is that that these proceedings are not deemed criminal proceedings, and that children should be treated as, not as criminals, but as children in need of aid, encouragement, and guidance. So it's very similar, even though it's the purpose clause for the delinquency criminal cases, it's very similar to the section 1, the general purpose of the care and protection proceedings. So getting back to Richard and his charge for delinquency by reason of having, assaulted this other kid with a hockey stick. But let's put them all up there. So what about the brick throwing incident?
Gotta have the same thing, another count.
Yeah,
assault.
exactly. Another type of count, and it's probably really similar. It could be assault, it could be assault and battery, it could be assault and battery with dangerous weapon, the brick, and so forth. What about the suspension essay? And you should recall one of the cases that you read.
Yes, the Milo case.
Yeah, so he
So
could
it's
be,
the threatening statute.
it could be a threatening thing.
Which I think was section 2, if I remember.
Of what? Of what statute?
I got it right
If you have it, we'll throw it up there. If not, it's not that big a deal.
275, subsection 2.
275. I knew it wasn't 265. 265-2 is the murder statute. Okay. So let's first just talk about delinquency cases a little bit. Now, you recall when we read the Galt case way back, first class, and we talked about the 4 important rights, right, due process rights, that juvenile defendants had to get constitutionally. Do you remember what they were, anybody?
One's notice.
Notice. And actually, let me talk about notice first, and you could be thinking about the other ones, because Section 55 of your statute talks about the summoning of the parent or the guardian. So remember, we talked about not only that Jerry should have gotten notice, but his parents as well. So again, it comes back to that these are not really deemed to be criminal proceedings, even though the kid has violated a law of the Commonwealth by virtue of the fact that this is a kid, that this is a child, and the parents have custody, and it goes back to the parental rights that we talked about way earlier, that they should get notice as well. So they're involved, even though it's Commonwealth v. Ortiz, and obviously the parents don't get counsel. And remember, and Michael Kelly brought this up, the Hillary case in the CRA statute, child gets counsel, but parent gets counsel when? Only if, do you remember? CRA.
Only if there's a risk that they're going to have the custody taken away.
Yes. So if DCF is somehow going to get involved. And remember that's also the worst case scenario for a CRA case. So if you have a kid that's, again, either run away, been truant, disobeyed school, or home, no matter how many times he keeps coming back to court, he's not going to be put in a place that he can't leave, except that it could be, a place, again, that is run by DCF. But DCF is the agency that strengthens and encourages family life. It's not the agency that punishes like DYS is. So DYS is the agency that's involved with your delinquency cases, your youthful offender cases. And obviously parents then do not get counsel even though they're involved in the delinquency cases. They get the summons, and frankly, I've heard judges say, well, okay, here's Johnny, the defendant, the juvenile defendant, where's his parents? And they've actually, issued summonses for parents that just for whatever reason didn't show up. So they expect at least a parent or a guardian, to be coming along when juvenile is arraigned or a status conference or going to do a plea, etc. So that's the notice requirement. Have you guys been thinking about the other one? The other three? Okay, Jennifer?
Right to counsel.
Okay, so the right to counsel, and that's in the statute, obviously. So you had the right to counsel in the care and protections, you had the right to counsel in the CRAs, and obviously with more rights at stake, because a juvenile could now be, as a result of committing a crime, put in a place that he or she can't leave, so the liberty right is at stake. So they do have right to counsel. And the other two were, Laura?
Right to confrontation and cross-examination of your accuser.
Yeah.
And then right to not self-incriminate yourself.
Yes, yeah. So what I didn't give you is the rules of criminal procedure. And the rules of criminal procedure apply to delinquencies. So even though you're in juvenile court, the rules of criminal procedure apply to your delinquency and youthful offender cases. So in terms of motion to suppress, any of those procedural vehicles are not only used but mandated to be used by competent counsel representing kids. What about jury trial? Now you're going to read one of the cases you're going to read for next week is MacGyver v. Pennsylvania, where the U.S. Supreme Court held that juveniles don't have a right to jury trial. But
statute that you
exactly. So
have to have a jury trial unless it's waived.
Yeah. So 55A is an example where Massachusetts affords more rights to kids in delinquency and youthful offender cases. As Michael said before, CRA's chins used to have right to jury trial. They did away with that. So there's the right to jury trial contained again in the statute, an example of more rights to the juvenile. So where you had the counsel for DCF prosecuting, for lack of a better word, the care and protection cases, where you have in CRA cases possibly DCF counsel involved in all of your youthful offender and delinquency cases. It's the district attorney office that prosecutes the cases. And obviously, what's the standard of proof? This is easy. Beyond a reasonable doubt. So the elements, of the crimes the juvenile is charged with doing have to be proved by the district attorney beyond a reasonable doubt. That's the adjudication phase. So, other than the fact that the defendant that allegedly did this crime is a child, for all other purposes, the criminal trial follows, you know, the rules of procedure as any adult trial would have.
Except it's not considered a criminal trial.
Except it's not considered a criminal. But do you see the conflict? Because you have on the one hand, you know, a court that was created so that kids would be treated differently from adults, so that they didn't hang them like they did, you know, hundreds of years ago. And yet, you know, back and forth, part of it is the explosion of the due process rights that began with Galt, you know. The proceedings became, you know, more adversarial. But yet, the juvenile court still retains that philosophy of best interest and trying to help save, quote, the child. So if Richard Ortiz, if the Commonwealth can prove that he assaulted, you know, with a hockey stick, and whether it's the worst case scenario, well, I haven't even discussed the worst case scenario yet, but I will in a minute. A and BDW, the brick throwing, A and BDW, and the threats, that's the adjudication phase, but now the court has to decide what to do with him, right? The dispositional phase. So we have a process. Well, no, I don't want to talk about that for, hold on 1 second. Suppose that Richard decides not to go to trial. I'll talk about the disposition in a minute. Not to go to trial. And, you know, his counsel has talked with the district attorney, and let's say it was the hockey stick. And it wasn't really a broken nose. He just, you know, the kid had a bloody nose. Richard didn't hit him that hard. It was plastic bag. Okay. And so, first offense, he's only, how old is our Richard? Is he 15? 15?
It said
He was born in 98.
All right, we'll make it up. We'll say he's 15. Okay. And pretty good student, etc. So there's some sort of negotiation, you know, relative to a plea agreement, district attorney and defense attorney. And they decide that he is going to plea, and he's going to plea, say, to simple assault. Okay? What do you suppose transpires at this plea hearing as we've been talking about, you know, juvenile rights? We just said that he had a right to counsel, that he had a right to jury trial, that he has privilege against self-incrimination, so he doesn't even have to testify, that the Commonwealth has to prove the case.
Well, he's going to have to waive all those rights first.
Yes, yes. Yeah, so something we'll be talking about next week, and you have to actually read, I believe, some cases on, you know, what's effective waiver? You know, what are the pretrial rights that a juvenile might have, also even before court, as to admissions and confessions and things like that. And is it, you know, we have the involvement of the parent and the involvement, obviously, of the attorney that may safeguard whether the juvenile has, in fact, you know, made a valid and effective waiver. Have any of you in your observations observed a plea? No? Okay. Surprise. Usually they
I
always
think we did.
plea. You think you did?
Christine did.
Yeah, did you observe a plea, and I know every juvenile court judge down there will conduct what's called a colloquy, that's why I'm wondering if you
I
have...
think the child, he was already in a group home, and he did something, and he pled guilty, and the judge just redid his probation orders and stuff, and said like he couldn't leave the group home unless it was for medical attention or school purposes.
Did you, I'm not sure if that was a plea or not. If it was a plea, you would have heard the judge conducting a colloquy, meaning, you know, Stephanie, you know, how old are you? You have been going to school every day. Did you have any drinks or drugs? Did your attorney explain to you that what you're doing right now is waiving a constitutional right? You know, you have a right not only to a trial that might be before me, but also you have a right to a jury trial, and you are waiving that right today. And by the way, at the trial, you don't have to do anything. blah, 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 blah. So the judge really, and the juvenile court judges go over it. I mean, in adult, they do something similar, of course, because it's still a plea hearing, and judges have, but in juvenile court, the judges, they go the extra step to make sure, to ensure that the juvenile really understands what he or she is doing. Stephanie?
I was wondering, in the case of truancy, where they called in the mom, this particular place in observation, the kid was third grade, and the mom wasn't sending the child to school. And so the judge asked, are you entering a plea of not guilty, and they ended up having...
He must have been charged with a criminal, it must have been a combination CRA and delinquency.
Right, it was a, I guess the juvenile court, but the parent was called in, so that was kind of weird.
The what?
The parent was on, basically the parent was in the hot seat for a criminal, for a crime because she didn't send her child to school.
Oh, I know what you're saying. Yes, and there's a provision, and I forget if it's in 119 somewhere, that an adult could be charged with contributing to the delinquency, that sort of thing.
Right.
Yeah, that's not what I'm talking about,
Okay.
a similar thing, but I'm talking about in the context of, making sure, one of the things we'll be talking about, and you may have heard about, the whole, explosion in research over the last 20 years, in the brain research of kids, and whether in fact they really understand stuff like this, as well as their own actions. So the judges are very, careful to even, and granted, they have an attorney with them, and the attorney should also be explaining. And sometimes you kind of cross your fingers or, hold your breath if you're the attorney, because you want to make sure that your client says, oh, my attorney did great, I understand him, or not something like, well, he told me to say that, I don't know what's going on, So that would be, whether that would be a plea colloquy. Same thing goes in terms of waiving rights. So the juvenile has a right to jury trial. So they actually have to sign a form that either they or their parent or the attorney, if they're going to waive, they're waiving jury trial. They still could go to trial, but it would be the trial before the judge. So again, they're waiving a right. In this case, it's a statutory right of Massachusetts to jury trial. So you see that as well in the juvenile court. Now, what's worst case scenario for Richard, if the Commonwealth proves any of these offenses, is commitment to DYS. Obviously, you don't want that to happen. So, and there are different versions of scenarios where he wouldn't be committed. He, allowed to obviously stay in his home with his mother, but with, say, probation. His case could, depending on the seriousness as well as his record or non-record, his case could be continued without a finding, which would mean that on that day, the judge has heard sufficient evidence in terms of the Commonwealth, proving beyond a reasonable doubt the elements of, say, the offense of assault and battery. But the judge is not going to enter a finding either way and continue the case. It's usually like for a year. And then at the expiration of that year, it would be dismissed as long as the kid doesn't come before the court again. So you'd like to have something like that if you're defense counsel. So, I mean, he still has a record in terms of delinquency, but it's continued without a finding. Jim?
Professor, how much weight is given to...
By the way, I'm looking if you want, 55B is everything that I'm talking about here, the disposition, etc. I'm sorry, go ahead.
How much weight does the DA or the court give to the victim? Does the victim have to sign off on anything, or does the victim have a say as to what type of...
So yeah, as in adult proceedings as well, the victims do have a say, and they can make whether it's at a plea or the conclusion of trial, a victim witness impact statement, which they can make to the court. How much weight it has, some way, you know, and again, it depends on the case and the circumstances, et cetera, but they certainly have the right to be, and there's a victim section of the district attorney's office. I'm not sure exactly the term, but yeah. And obviously, with the more serious crimes is where you see, you know, the victim or a representative of the victim actually standing up, and or sometimes they present something in writing as well.
The only reason why I asked
Yeah.
that, Professor, is it's a little bit, at least it was when I was working in New Hampshire, it was somewhat frustrating that in juvenile cases, when a juvenile took a plea, we couldn't actually go back and tell the victim what the resolution of the case was, because it was under it was sealed under the juvenile law, so you couldn't go back and say to the victim, he's pled guilty to, well, they don't even say plea, it's true or not true.
Well, that's kind of odd that the victim wouldn't have been allowed to actually be present.
In a juvenile,
Yeah.
in a juvenile proceeding,
Yeah.
not.
I've actually been present at one of those hearings on the victim side. And so again, it depends on, you know, the district attorney's office, about, you know, how involved you are too as a victim with the case, and whether you're following it, whether you get notice. But it's certainly a right that you have as a victim. That's too bad. Yeah.
In fact, when they go in, the victim cannot be there when they plead. This is in New Hampshire now.
Okay. Interesting.
I've been out of it for 2 years, but
Yeah.
before that, for the last 20 years, it's quite frustrating to go out and tell the parents of a victim that had been assaulted that they cannot be in the room when the juvenile takes the plea, and then we can't go out and discuss the case.
That's too
after.
bad, because the victim's not getting a voice. And as an aside, Lowell is on the forefront in terms of the restorative justice process and diversion efforts. So they have a program by which, you know, as long as the victim and the offender, and it depends on the type of case, are sort of, you know, in it, the offender being, feeling that he or she is accountable, the victim wanting to engage in the process, they actually get together in circles with, you know, representatives of all the sides. And it's so much better than, like you said, the victim really, the victim is the person that was hurt, and yet they feel like they have no say at all in the process. Yeah, so we'll talk about that more, maybe. So you're going to you could have a continue without a finding, you might be placed on probation, you might have a suspended sentence, DYS, same sort of thing. You get in trouble, you're going to be, the probation department's going to violate you, you're going to appear on your violation of probation hearing, like what you were talking about, and you're going to go bye-bye to DYS. But that's the worst case scenario for delinquency. DYS is, you know, an agency similar to DCF, an agency that deals with youth. In this case, it's a punishing kind of agency, but it's also, because it is children, engaged in rehabilitation, etc., as well. So, so that's the 55B, the provisions of disposition for a delinquency case. Now, this is going to get tricky with your youthful offender cases. Remember, I talked to you guys about transfer hearings and how the Commonwealth had, in fact, the legislature had abolished, repealed the transfer provisions of Chapter 119 back in 1996. So what used to happen is you'd have a delinquency case in juvenile court, and it might be a pretty serious case: murder, you know, rape, kidnapping, assault with a dangerous weapon, right? And in instances where the offense was so horrific, and or the juvenile really was the type of person that really couldn't be helped by the juvenile system. The juvenile courts used to hold hearings in the juvenile court to decide whether the child should be tried in the adult court, in the superior court. And so these hearings were called transfer hearings. Well, the Commonwealth decided that was going to do away with this procedure and have almost every case except murder cases, and I'll come back to those, held in the juvenile court, but when they are the more serious, they would be indicted in the juvenile court as what are defined as youthful offenders.
Doesn't the age change on that too?
Yes, and the age changes. Not only does the age change, but the circumstances are a little bit different. So what's important is age is 14, it used to be 14 to 17, so now we're talking about 14 to 18. Okay. And there are a few provisions. One is having been in DYS before, another deals with gun charges for purposes of what we're talking about. The one that's important is the infliction or threat of serious bodily harm, something like that. You have it in your statute. So here's the thing. Except for maybe the threatening, the suspension essay, and again it depends on how serious that was. We can at least talk about both the hockey stick situation and the brick throwing situation as being two acts that possibly the district attorney might be thinking about filing a youthful offender indictment.
But I thought even with the infliction or intention, there has to be a previous history.
No.
No?
No. The previous history is the or. If you look at the definitions of youthful offender, no. For example, remember and I forgot her name, the girl that hung herself after being bullied. What was her name?
Oh, the 6 bullies.
The Irish girl.
The Irish girl. What was her name? Well, anyway, all of the kids that were involved were actually indicted as youthful offenders. Yeah. So, again, it could be just one instance if it falls within that statutory language, infliction or threat of serious bodily harm. Phoebe Prince, that was her name. Yeah, that was her name. So, what that means is now, how does a youthful offender case get going? So, for example, with this delinquency complaints, right? School would have alerted the police. There'd be an investigation. A complaint would issue through the juvenile court department. All right. In whose sort of hands is the decision to, you know what? Forget a delinquency complaint. It should be a youthful offender case. Whose decision is that?
Would be the judge. Or the district.
Amanda says the judge. Jim says district attorney. Michael?
Prosecutor, district attorney.
It's the district attorney. And that's important because in the old days, the transfer hearings, it was really statutorily. It was the particular acts that could be subjected to a transfer hearing, and the decision was the judge's decision after the transfer hearing whether to transfer the child as an adult. Okay? So this decision is the district attorney's to indict Richard Tiz as a youthful offender. So what does that mean? How is that different from the delinquency case? One of the things about when the new law got changed, I mean, it was a big deal, a big uproar, like, oh no more transfer hearings. everybody went crazy, and the proponents of the youthful offender law said, well, you know what, we're almost doing just the reverse of what we had before. So we have trial first. So he goes to trial in the juvenile court, okay, on whether, he assaulted with a hockey stick, whether he threw the brick and hurt another kid. Goes to trial. Trial is conducted like, again, what we just talked about, any other criminal trial, except it's, it's in juvenile court. The defendant is a juvenile. District attorney is prosecuting. The defendant is represented by, defense attorney. If the Commonwealth, again, proves the elements, what then becomes different is you have what's called a sentencing hearing. And that hearing is very similar to the way they used to do the old transfer hearings. So in that hearing, the judge considers not only, that incident. So what could the judge consider about Richard before he or she sentences Richard, Jim?
Prior bad acts.
No, about Richard himself, right? So now, okay, we've finished the trial piece of it. We finished the adjudication. Now we're going to go to the dispositional part, but before that happens, we're going to conduct this full sentencing hearing. We're going to consider the youth and his circumstances. Amanda?
Any circumstances, like his family life, his development.
So what about Richard from the few facts that
he's gay.
might... What's that?
He's gay, right? He just moved here with his mother. It's a new area, it's a new environment. Either he's taking well, he's not taking well to it.
Good student.
He's a good student. Anything and everything, really, the judge can consider. But the overall standard is what? And I'm looking to see where it is in the statute so you guys can find it too. Yeah, so if you look at section 58 and after where you see A, B, and C, and I'll come back to that, the next paragraph after that, sentence recommendation hearing, the public safety. To determine the sentence by which the present and long-term public safety would be best protected. So that's what's also different about this sentencing hearing. The judge is not just considering, as in the old transfer hearings, gee, should I transfer this kid because he or she can't be rehabilitated? And in a sense, obviously, the public safety was still considered back then because the court also considered, is he or she, dangerous? Let's look at the nature of the offense that he or she committed. One of the cases that you're going to read, Commonwealth v. Matthews, and I think I've talked about that case before. That kid had no prior history at all. But because he bludgeoned this other kid with a baseball bat, and then left his body, back in the woods, and then kept bringing kids after school to look at the body, he was transferred. And he got, life with parole. He's in his 30s. He keeps coming up. He's come up for parole before and has not received it, So again, what was overriding was not whether he could be rehabilitated, but more the incident itself. So what the court looks at is, again, the overall standard is, the public safety, and then the court has 3 alternative decisions, right, to make. So where we had worst case scenario of the 7 to 18-year-old who had just a straight delinquency complaint, we have a much worse scenario in the sentencing hearing. So there are 3 choices, right? And all of a sudden, everything went dry. Yeah. Oh, that's better, okay. First choice is?
The punishment of whatever the crime is, if there was an adult, right?
Wait, that's worse. Let's go with least first.
Yes, sir.
Least first? is?
DYS.
Yeah, delinquency. Any delinquency disposition. So all those that we just talked about, continue without a finding, probation, suspended sentence, DYS, are all possibilities at the conclusion of this trial, because he's still treated like a kid for purposes of, let's just consider all of the facts and circumstances, and maybe he's still going to get what he would have gotten if it was a delinquency complaint in the first place. Or we also have the next one, which is sort of what we call the combination, right? Part DYS and part Department of Corrections. And then the worst that you just talked about before is the, what they say is the sentence required by law, right? Which is an adult, whatever the adult sentence is. So even though you're hearing a case in juvenile court, it gives the juvenile court judge the power to issue the sentence, not only the sentence that an adult would receive, but a Department of Corrections sentence. So in scenario A, you have DYS involved. Scenario B, the combo, DYS partly, and then DOC, Department of Corrections, and then the sentence required by law, Department of Corrections. Okay.
When you have the combo, is it like DYS up until age 18, then transferred to the DOC?
Yes.
Okay.
Yes, and that's B. It's subsection B of section 58 of your statute. Now, what's interesting too that I wanted to point out, and are we still looking at 58? At 58 is really long, but almost at the very end of it, there's a big paragraph that starts, except in cases in which the child has attained the age of majority. It talks about, remember in the care and protection cases, and in fact when we did the Sissy Harrison scenario, one of the things that the department had to show was that the department had made reasonable efforts. Do you remember that? Before, removing the child from the home, and the judge had to certify, and in the care and protection statute, it's under 29C. We always call it the 29C certification. The judge had to certify that there were reasonable efforts were conducted before losing custody of the child. That requirement is in here as well, because again, we're still talking about children. So in any case, CRA cases as well, in any case where you have a child and the family is going to lose custody, there still has to be what's called this reasonable efforts requirement. And it actually goes way back to, we didn't used to have this in the statute, and up through maybe 94 or so. But there was a federal statute that allowed like DCF, DYS to get this federal funding. And we always talked about it was the reasonable efforts requirement. So at some point the legislature in Massachusetts wrote it into the Mass statute. So it's all about money, basically. Are you giving these agencies enough money? But they have to show that they've made efforts before taking a kid and spending money on the kid.
Can I just clarify something real quick?
Yes.
So when you were talking about 58 and the three
Yes.
worst case scenarios, under C it says, a commitment to the Department of Youth Services until he reaches the age of 21. Is that up until?
Oh, I have it I'm sorry, I have it the other way on the board. The A, according to the statute, is what I put as C, because I always go least to worst.
Yeah.
So, go ahead.
So yeah, I mean, so it says until he reaches the age of 21. Does it have to be until, or that's up until?
It doesn't have to be until, because now you're talking about DYS also, helping the child, maybe at some point he's in a group home.
19,
yeah, he might be doing better in DYS, maybe, really, but yeah, exactly.
Just the way it was worded,
Yes.
it made it sound like
Yep.
it has to be till he's 21.
Yep. Ask questions, because I think this is all I wanted to give you guys a framework for before you read the cases. I'm trying to think if there's anything else I wanted to. Oh yes, I'm sorry. Yeah, because Jen is in writing class, so is Amanda, now, and so is Stephanie, and so is John, oh my God. And so is
Useful
Jim.
information right now.
So we have other cases, right? So suppose that, oh God. Suppose the, which one do we want to kill? The hockey stick situation or the brick?
What do you mean kill? Take it
Because
away?
suppose the kid died.
The brick.
The brick.
Oh,
Brick.
all right, yeah.
The brick, all right. Okay, so the kid dies, right? District attorney could, so these are the choices. You tell me. Brick throwing incident, he's being, harassed allegedly. So throws the brick, the kid dies. Jim, what are the choices in terms of the district attorney prosecuting, what's his name, Richard Ortiz?
There's several, it could be, he could charge him in the juvenile court.
With what?
Maybe manslaughter?
Yeah, exactly.
And 14,
So, so if the charge is manslaughter, it's going to be as useful offender. Suppose it's more serious. I'll put it over here. It's more serious than manslaughter.
second degree murder.
What court?
That would,
So now we're,
the juvenile court doesn't have jurisdiction over that from 14
Yeah.
to 18. It goes up
Yeah.
to the superior.
so 119, I believe it's 74 or 72, right? Says that the juvenile court does not have jurisdiction of murder cases. So everything that we've talked about, for any crime, even manslaughter, Richard Ortiz would be prosecuted in the juvenile court, even though he could receive an adult sentence, right? But if the charge is going to be murder, he's now in superior court. And one of the cases that you have to read for next week is Miller v. Alabama, that held that mandatory life without parole violated juveniles' Eighth Amendment rights. And so what that meant for all states, and we'll get into that in more detail next week, what that meant for all states is that states could still give a life sentence, but they have to do it after they consider the juvenile's youth and circumstances after some kind of sentencing hearing. And just to back up from that point, we have in Massachusetts, when we're talking about murder prosecutions of juveniles, not only are we talking about 119, but just like we put these statutes up here, Chapter 265, we have mandatory sentences for people who have been prosecuted and receive, where the Commonwealth proves beyond a reasonable doubt, murder one, mandatory life without parole. So that sort of was as in the sort of culmination, so to speak, of this whole, adolescent development theories, research in neuroscience and psychology and biology, etc., that where both psychologists, sociologists, scientists, and even lawyers started to look at and started to argue that juveniles, they can't process all this. They don't have the capability, etc. So the Supreme Court actually began to recognize that theory in holding the death penalty, unconstitutional. And then at another point held that, they shouldn't receive life for, for crimes that are not homicides. And then lastly, with Miller v. Alabama, that was just decided a couple of years ago, not even a couple of years ago, mandatory life without parole being unconstitutional. I didn't give you, because when that's right, because when I was putting this together, on Christmas Eve of last year, our Supreme Court, the Supreme Judicial Court, decided two cases, and our writing people can talk about those cases next week when we get to these U.S. cases. But our SJC decided that Massachusetts, again, more rights, decided that, you know what, life without parole, period, violates the Massachusetts Constitution. And so what that means for juveniles today is worst case scenario, they're going to get murder 2, life with parole. And in fact, it came... What's that? Yeah, only for juveniles. Yeah, the SJC. In fact, it came about as Diachenko was an old case. The SJC decided in '82. And at the time, the defendant, I think, was charged, I want to say when he was 17. I don't 17. Even... Yeah, he wasn't even in juvenile court. He was in Superior Court. If it's somebody... correct me if I'm wrong, but I don't think it was a juvenile case, but he was young, okay? So like today, he would be in juvenile court because it's up to 18. So, but anyway, one of his arguments was, you know, you need to consider my youth, and that his main argument that he took to the SJC at that point was that life sentences, you know, violate the Mass Constitution. And that was his last appeal. SJC shot him down. He was doing life, and then Miller was decided. So his attorney files an appeal with the court arguing not only retroactivity of Miller, but arguing that in Massachusetts, life without parole, period, should violate juveniles' rights. He was successful. At the same time, a companion case, which wasn't an older case, that defendant's name was Brown, he had just gone through trial. And again, the attorney was like, what do we do about Miller? So they appealed that case as well. And so they're companion cases, again, that stand for the proposition that life without parole violates the Mass Constitution. And that juveniles, therefore, you know, that are indicted for murder, whether it's murder 1 or murder 2, worst case scenario for them is going to be life with parole. So in terms of crimes, that's sort of the gamut of where your juvenile defendant might be. To make this even more involved, if you had more facts, maybe Richard Ortiz was even, you know, abused or neglected at home. And it could be a care and protection case. You know, maybe he's acting up, you know, at school, or, you know, put into it, you know, the bullying issue as well as the gay issue. You might have a parent, you know, the child not really wanting to acknowledge because he's afraid of coming out to his or her parent, and because of that, the child doesn't want to tell anyone in school about being bullied, and consequently the child begins to resort to violence. What about the kid in, I want to say it was Pennsylvania, that recorded, you guys heard about this?
Yes.
Recorded himself being bullied, and he gets charged as a result. But I heard that was going to be dismissed. But still, I mean, the poor kid who decides to come forward with some kind of proof, instead of the bullies getting some kind of repercussion, he gets charged with criminal.
Do you know how old he was? Does anybody know how old?
Like teenager.
Yeah, I think he's like 16 or
Look it up, Mike. He was on Facebook. He was what?
I
16?
think he was like 16, 17,
Yeah.
seniors.
Mm-hmm.
It's terrible.
So any questions up until now, Jim?
Just one, Professor, on the, since Diachenko and Brown,
Mm-hmm.
just for my edification, can you still technically, even though it wouldn't have life without parole, can you on paper technically charge a juvenile with first degree and murder, but he can only get...
I don't know. And the reason why I say I don't know is obviously this was just decided December. So I believe there might have been some kids that were originally charged with murder 1. But
murder 1, I assume, involves a premeditation. So if the case
exactly,
involves premeditation,
exactly.
Can you still
That's so
technically charge it
it's
as
like
first offense?
confusing
Yeah.
because you have, you know, the case from the feds, the Miller case. Then you have Diachenko v. Brown. Then you have our statutes, which haven't been changed And even Brown, the Brown court urged in December, the legislature should be doing something. I mean, Miller was decided 2 years ago. Forget that Brown and Diachenko was just decided, but Miller was decided 2 years ago. Why didn't the legislature, they changed the age to 18. Why didn't 119 get amended? So they need to get on the ball, I think. But that's a good question.
He's 15.
He was 15. Was it Pennsylvania?
Yeah.
Yeah. So,
So what would happen with like the vehicular homicide?
okay, so yeah, again, it's going to depend on if it's some kind of, more than likely it's manslaughter, depending on the facts.
Would
Unless
they-
you have a kid that you intentionally killed with his car or,
It's like
yeah, yeah.
OUI case.
Yeah,
He was at
it-
a party, he was drinking.
Yeah.
Would
It
they
w-
have a hearing to charge him as an adult? or-
No,
It
it's
just
a
would be
YO, it's a
automatic?
YO indictment by the district attorney. It goes to trial. District attorney proves the elements of vehicular homicide. Choices again, least to worse, DYS combo,
So
Department
it's
of
automatic
Corrections.
if he's under 18, he'll go into,
What's that?
it'll be in,
No, they are choices.
no, but I meant if he's under 18, it'll automatically be in juvenile court. It won't go.
All of this, again, the only time we're talking about adult court today is if the charge is murder. Okay? But a juvenile court judge can still give an adult sentence in the youthful offender situation.
Does that include more age group? Like a DUI case, we have somebody that's 17,
Yeah,
so they're not brought
Yeah.
to an adult court as far as more people.
no, as of September, and I forget when the statute actually went into effect, but the legislature passed the age of 18 in September. Yeah. No questions? You want to read the cases for next week? We'll do the U.S. cases on Tuesday, and then the Mass cases for Thursday. Okay, all right. Thank you.